crashes, defective products, dangerous drugs, injuries, and abuse. Across the state of Alabama, the attorneys, proudly sponsored by the law firm of Hollis Wright, are here to serve you. Your tough legal questions answered by our experts with host David Lamb and the attorneys of Hollis Wright.
Good evening and welcome into the attorneys. Thank you so much for joining us tonight. Got a really interesting panel of guests, an interesting topic of conversation in you, so we got everything we need. Here are the ground rules for the show, just in case this is your first time with us. Throughout the show, on the bottom of your screen, you'll see ways you can call, text, email, and get in touch with us. We would love to hear from you. The show is always better the more involved you are. Also, Hollis Wright makes available during each and every show attorneys from the firm who are standing by live to speak with you. So that's a free, off-air, confidential conversation, a great opportunity that is yours for the taking, so take advantage of that. Leading the conversation tonight is Michael Eldridge from Hollis Wright. How are you doing, sir?
I'm doing good. How are you, David?
Doing very well. Looking forward to tonight's show. It's kind of, once again, it's a timely topic for us.
It is. It's like every legal topic. For the most part, we hope that our viewers don't have to deal with whatever we're talking about, because usually it's something that's tough or something they're trying to get through. But this one's no different. But it's also one that, unfortunately and inevitably, either you as an individual or at least someone that you know is probably going to deal with, and that is the criminal justice system and criminal law. And it is a specialized type of law and a different justice system that we're used to at Hollis Wright. We just learned about it in law school, so we bring our friends in, and that's why we've got Josh Jones here, who is a criminal defense attorney, former prosecutor, so you know both sides of the law. Welcome. Thanks for being on, and tell us a little bit about yourself and your practice.
Sure. Thank you for having me on. Of course, I have my own practice here in Birmingham now. It's about 11 years. Before that, I was 5 years at the district attorney's office in Montgomery. So lots of jury trials, lots of in-court time, but criminal defense is what I specialize in now.
Gotcha. Well, we were talking before, and I was saying that although I've never done anything on the criminal side, on the civil personal injury side, for the first half of my career, I've defended trucking companies, and now I'm on the other side of it. Sometimes it helps to kind of, once you get into the legal system, to know both sides, and to know how prosecutors think, to know how criminal defense attorneys think. But for our viewers, and I think for me, maybe, hopefully not, I think most people's questions is, you get in that situation, unfortunately, you've been arrested, what do you do next? What's your first move, and kind of what's the do's and don'ts when you're in that situation?
Sure, great question. Of course, everybody that would be in that situation would, want to know the answer, and it's something definitely concerning. When you're arrested, of course, when you get a chance, you're going to obviously go to jail, but when you get a chance, you would want to contact an attorney. If you had an inclination that you were being investigated, you may would want to contact an attorney beforehand. However, once you get arrested, you would go through the jail or the criminal justice system as far as getting in, booking, bonding out, and then contacting an attorney. There's a lot to it, and of course, we don't have the time to get into all that, but contacting an attorney as soon as you got out would be the best step for you at that point.
Can I ask, we're kind of living in a time where there really is a debate about how respecting police officers, and that's kind of just been in the news, and there's a kind of a debate there. I'm much older than either of you, and I was always told, respect authority, respect your elders. So what do you advise your clients if they do get arrested? How should they treat, even if they're completely innocent, how should they treat that arresting officer?
Sure, of course, and that's another good question. I tell everyone, whether it's a client or a potential client, to treat law enforcement with respect and with courtesy, just like you would anyone else. Furthermore, they have a badge and usually a gun, so things can escalate very quickly. Of course, nobody wants it to escalate. No one wants a bad result like we've seen on TV or the national news a good bit, but you have to treat people with respect, and of course, obviously treat law enforcement with respect. It usually goes over much better when you're courteous, respectful, and not getting loud and belligerent, arguing, yelling, and cussing back and forth. It usually goes better.
Yeah.
You've mentioned earlier that if you have been arrested, unfortunately, and you've been booked, as soon as you can, you want to get an attorney involved to represent you and represent your interests as soon as possible. And you talk about beforehand the way you want to treat law enforcement. What if in the interim, if you've been arrested, you're in handcuffs, I know every situation is probably different, but people always say, don't talk to the police or stay silent, demand an attorney. What's your tips in that situation? Are there situations where if you are in handcuffs, you're being investigated where it's smart to talk, or is it typically better to remain silent until you can talk to your attorney?
I would say in almost every situation, it is best to remain silent until you speak with an attorney in the criminal world. Now, a civil world or family law, something else, that might not be the case. But every person that is in the United States of America has a constitutional right to remain silent. They don't have to tell their side of the story, and a lot of people, maybe it's just human nature, feel compelled to express their innocence. But in the majority of criminal cases, that usually comes back to bite them. But because law enforcement is there to investigate a crime or investigate something that may have happened, they do not have necessarily that person's best interest at heart. That's not to say anything negative about law enforcement. That's just not their job. Their job is to investigate the crime. So if you blurt something out, or you speak out of turn, or you just start expressing your concerns about the case and talking about everything, you very likely may be incriminating yourself, and so I do not advise that.
Yeah. One thing though I've always thought about, can they then, let's say that you say, I'm going to remain silent until I talk to an attorney. If one day it does get to a trial, can they use that against you? Can they say, we tried to ask him and he said he wanted to remain silent?
Absolutely not. Multiple jury trials and bench trials I've been in, that has come up, and that cannot be used against that particular defendant as some type of negative connotation or negative fact about the situation, and a good attorney would try to keep that out if that were suspected to be brought up.
Can I ask we got a question here kind of along these lines. I wasn't read my Miranda rights. Can my case be thrown out?
Generally, people have that misconception. Just because a law enforcement officer does not read a person their Miranda warnings, and they're called warnings, not rights, because they're not necessarily in the Constitution. It's case law, Miranda v. Arizona. It's not going to get thrown out just because of that. Now, what would happen is they normally cannot use a statement that they would take from that person if a Miranda warnings were not read to the person or explained. It's not going to automatically get your case thrown out because they can already prove their case without the confession or without the statement. They may not even need that statement. They may not need to use it in court. But if they did not read you your Miranda warnings and they try to use that in court, a good attorney would be able to keep that out.
And when you say Miranda warnings, you're talking about the right to remain silent, things we hear on TV, right to an attorney.
Correct.
You can't afford an attorney, one will be appointed to you. Those are, and what you're saying is it doesn't necessarily mean that you don't have a case. For example, if you had a DUI and you blew, that may be all the evidence they need. But as it relates to a statement, that's what those warnings are for. Sure.
The Miranda warnings are what you see on TV a lot. Every time someone gets arrested on TV, it's just one of the popular things that they use on TV. But it is really only dealing with statements. It doesn't deal with other evidence, only statements from that defendant.
Okay. We need to step aside. Our first break of the evening as we do so. A reminder, don't forget to check Hollis Wright out on social media, Facebook, Twitter, Instagram, YouTube, wherever you are, they are. Just search Hollis Wright and you'll be able to find them there. Stay tuned. We're coming right back.
I'm Josh Wright with the law firm of Hollis Wright, a personal injury law firm, and thank you for watching The Attorneys. We hope you, a friend, or a loved one never needs legal counsel for a case. But if you do, the goal of the show is simple: to provide answers and legal counsel when you need it the most. Your call to the show is free and off air. So if you have questions specific to the show or related to other accident or injury topics, call, email, or text us. You can also follow us on Facebook, Twitter, Instagram, and YouTube, or go to hollis-wright.com and click on the Contact Us button. We know your time is valuable, so thank you for spending it with us and watching The Attorneys.
The Attorneys, proudly sponsored by the law firm of Hollis Wright, are here to serve you.
When we started the show 8 years ago, my hope was we would be able to do what we do best, which is to help people answer real-world legal-related issues they have in their life.
People oftentimes are confronting various legal issues and problems in their lives that range across the gamut of legal practice areas. Bankruptcy, criminal law, family law, just to name a few. And to be able to have a 30-minute platform or format to where we can just cover various legal topics once a week, that's obviously the primary focus of the show.
That we would be able to use the resources of the many lawyers we have at this law firm to create a plan that had a lasting impact that also gave back to the community at the same time. And I think we've done just that with the attorneys.
Welcome back. Thanks so much for being with us. Hey, just want to remind you before we get back to our conversation, attorneys from Hollis, Wright are standing by right now. Go ahead and get in touch with them. An opportunity to speak with an actual attorney from Hollis, Wright tonight. So a pretty cool opportunity. Back to our conversation here. I've got a question here. You guys were talking about DUIs when we went to break. So I've been pulled over for suspicion of DUI. Should I blow for the breathalyzer or should I refuse?
Sure, and I get asked that question a lot
I bet,
by
yeah.
friends and family and
right.
clients, everybody. The old theory was not to blow, so therefore they couldn't use that evidence against you in court. Things have kind of shifted the last 15, 20 years maybe on these deferred prosecution programs. A lot of municipalities and counties have it in their, through the DA's office or the bylaws, something like that, that if you refuse to blow on a breathalyzer, you are automatically ineligible for a deferred program. A deferred program would be where someone admits on the front end to DUI. However, they are into a diversion program where they pay some money, they get into a program, they have to stay clean for 6 months to a year, no drinking, no drugs, and also pay off their fines and court costs. And at the end of the deferred program, they can have their case completely null-prossed or dismissed and get it taken off their record. Right. That used to not be an option for people. So my advice these days on DUIs are generally kind of what we already talked about, to cooperate and to blow, because at that point you may be eligible for the deferred program later down the road once you get into court. If you refuse to blow, you're definitely 100% going to jail anyway, but you're also not allowing yourself the opportunity to go into that deferred program later down the road. So in my opinion, it's better to cooperate and blow at the scene, because you are eligible for that deferred program at that point usually.
So when you blow, the legal limit is 0.08 for an adult.
Correct.
If you chose not to blow, which is your right, just like your right to remain silent, how would a prosecutor, if they don't have that blood alcohol content, go about convicting you of a DUI? Is there another method other than blowing?
Yes, I mean the blood alcohol content, the breathalyzer, is just a presumption of intoxication. That by itself is not enough to prove intoxication. That's why police officers, sheriff's deputies, state troopers, anyone else, perform what are called FST, field sobriety tests. The walk and turn, the touch your nose, the horizontal gaze and nystagmus, which is what they use for a pen. All of those things can be combined in order to help prove a DUI. And a breathalyzer by itself is generally not enough. Even if you blow above a 0.08, it is generally not enough by itself to convict someone of DUI.
Well, we hear a lot about, and people ask a lot about, nonviolent offenders. I feel like that's come up a lot, at least in this area, with prisons being overcrowded, with whether it be drug charges or other things. And people ask a lot now with marijuana becoming legal in some states and some not other, and the federal government's changing. Obviously in Alabama, you can still be arrested for possession of marijuana, and there's different laws on the books. If you got arrested today for possession of marijuana in a state like Alabama where it is still illegal, can you face jail time if you're convicted of that crime?
You technically can. In my opinion, I have not seen anyone go to jail for marijuana in quite some time. Like you mentioned, the laws are changing not only in Alabama but across the country, and the sentiment regarding marijuana is changing. It has been a very long time since I've seen someone go to jail specifically or prison specifically for marijuana unless you're dealing with a trafficking issue, large amounts of marijuana. Personal use cases, those are not jailable offenses anymore.
Question we've got here, I was convicted of a crime 7 years ago. Can my record be expunged?
That is a maybe. Alabama has made significant leaps and strides in the last couple years regarding expungements of cases. We had a expungement law created several years ago that dealt with certain offenses but no convictions. Now we have a brand new expungement law in Alabama that allows for even a wider group of charges to be taken completely off your record. So the answer to that, of course, is it's an individual case-by-case basis. I don't know for sure, but you have a very good chance of getting it expunged under the new Alabama expungement law.
If a charge or a conviction is expunged, how does that affect your criminal record? Is it totally gone? And kind of a side to that, a lot of people ask me whether they're applying to medical school or law school or they have a job application, and people say, hey, what's your criminal history? How do you advise them to answer that? Because sometimes they're confused about when they were a juvenile or something maybe had been expunged. There's a lot of confusion about what they have to tell a potential employer or maybe a university.
Correct. My advice would be to read the question carefully. Sometimes they ask about convictions, sometimes they ask about criminal history, so you really have to read the question carefully, and I would only answer the question that they're asking. Of course, you want to be honest, and sometimes being dishonest just by itself will get you kicked out. Sure. But being honest and reading the question, if it's a conviction, that's one thing. That means you were found guilty or pled guilty in court. If it's a criminal law matter, that could be an arrest that was eventually taken off your record and would not be on your record. Also, if it's either youthful offender, if you're granted youthful offender for someone under the age of 21, or you're arrested and taken to juvenile court, that is not generally considered a criminal offense. A youthful offender is considered a violation of the Youthful Offender Act, and juvenile cases that are criminal in nature are technically called delinquency cases, and so that is not necessarily a criminal case either.
So in Alabama, the juvenile cases, though, that's going to be people that are under the age of 18 or 19?
Correct.
And then for youthful offender, what's the top age?
21 at the time of the offense.
Okay.
It could be 10 years later, but at the time of the offense, what was the age of that person?
And if it's I assume if it's a felony that the attorney should, anytime someone's under 21 should plead for youthful offender.
Correct. There's a misconception that you only get one youthful offender in your entire life. That's not true. It's a case-by-case basis. Every judge makes a decision on youthful offender, but the judge ultimately makes that decision based on the gravity of the offense, the circumstances involved in the offense, that individual's history, but anybody that's under the age of 21 should at least apply for youthful offender, and not just in felony cases. You can apply for youthful offender in misdemeanor cases, and in some jurisdictions, traffic tickets and things like that to keep it off your record.
Time for us to step aside. We're going to take our final break of the evening. The final segment of The Attorneys coming up after this quick break. Stay with us.
I'm attorney John Spade with the Hollis Wright Law Firm. If you have ever had a personal injury claim, the attorney handling your case has likely told you that a portion of your settlement would have to be used to pay back your health insurance company for the medical bills that they paid relating to your injuries. This is called subrogation. In this week's Legal 411, we are answering the question, what is subrogation and how does it affect your personal injury claim? When you purchase health insurance, you sign a contract with the health insurance company, which provides that in exchange for you paying a monthly premium, the insurance company will pay your medical bills when you're injured. Now, that contract has a paragraph that gives your health insurance company the right to seek repayment for the medical bills they paid if you in turn use those medical bills as a basis to recover from a third party that caused your injury. The idea is that your health insurance company would not have had to pay your medical bills if it weren't for the wrongdoing of the third party. Now, health insurance companies routinely put attorneys on notice of their subrogation claims by outlining exactly which medical payments the health insurance company is claiming a subrogation claim for and for what amounts. Throughout the handling of your case, your attorney should be aware of the amount of subrogation your health insurance company is claiming and whether all the claimed subrogation is related to your underlying personal injury case. That way, if your case resolves, your attorney can then negotiate a reduction of the health insurance company's subrogation claim. Subrogation is one of the many moving parts that can affect your personal injury settlement and what you stand to recover. Please remember, your call, email, or text to the attorneys is free. All of us at Hollis Wright want to help answer your questions on real issues you face. Remember, a competent lawyer will respond to every question you send in. That's our pledge and our promise to you. Thanks for watching The Attorneys on WBTM 13.
Welcome back. Our final segment of the attorneys. So the clock is ticking. If you want to speak to those attorneys from Hollis Wright who are standing by live, just about 6 minutes or so for you to take advantage of that opportunity. Before we get back to you to a question we've got here, you guys were talking about misdemeanors, felonies, and all. A question about what is the difference between a misdemeanor and a felony. Can you kind of separate those and define them for us, if you would?
Sure. There's in every state, as far as I know, there's misdemeanors and felonies. That's just something we've had since our time from English law. But misdemeanors obviously are the smaller of the two. Anything that can require a jail sentence up to 1 year would be considered a misdemeanor. Anything that would be considered prison time would over a year and a day up to life in prison would be a felony. There's also changes in the fines regarding misdemeanors and felonies. Felony fines could be higher, misdemeanor fines would be lower.
Okay. All right.
You talked about evidence earlier, and statements, for example, could be used as evidence. A breathalyzer in a DUI case could be evidence. Obviously, witnesses can be evidence. And one thing I hear about all the time is domestic issues, where somebody calls in and says, my spouse or my boyfriend or my girlfriend has assaulted me, and the arrest is made typically on that statement, right? The complaint that's made. I would assume later, sometimes, especially with spousal situations, that victim can sometimes change because they're in a marital relationship. How do defense attorneys and prosecutors navigate that, and how common is that?
It's very common. It happens a lot. I'd say domestic issues are the most common cases that I handle where someone wants to drop or dismiss the case. My advice as far as a domestic issue is once the police are called or a law enforcement agency is called, they ultimately make the decision on whether they arrest someone and who gets arrested. They can also arrest both individuals. So oftentimes what has happened is a heated situation, an argument, police will get called, one or more people at that scene will get arrested. Because even at the scene, if the spouse, the wife or the husband, boyfriend, girlfriend, anybody, they want to drop the charges, it's beyond their control at that point. And usually, from what I've seen, law enforcement, if they have probable cause to arrest, will go ahead and arrest someone just to cover themselves to make sure someone, after they leave, doesn't get hurt, doesn't get killed. So usually someone is arrested. And even later at that point, when they get into the court system, if they want a case dismissed, they don't make that final decision. The prosecuting body, either the district attorney's office or the municipal prosecution office, will make the decision on whether there's still enough evidence to go forward with it, whether they should dismiss the case, but it is no longer that victim's right to have it dismissed.
A question we've got here, which I find this is kind of interesting to me. My job application is asking about my criminal record. What should I say? I mean, I guess you don't, I don't know if you ever want to tell anybody to lie, but how do you advise folks to respond there?
Right, and we talked about this a little bit earlier. It just depends on how the question is written. It's been a long time since I've filled out a job application. Right. I work for myself now, but
makes it simple.
Yeah, it makes it very simple. You have to read the question as it is. If it's a conviction, you want to be honest. either way, no matter which way. And you can, of course, feel free to contact an attorney and see what they say, but you would want to be honest, and it depends on how the question is written, whether it's written as a conviction or whether it is written as an arrest or whether it is talking about criminal history.
One thing that I have a question about, because every area of law, right, there's a lot of different law questions, and if somebody calls me with a tax question, I'm going to say, call a tax attorney.
Correct.
But even within personal injury work, there's different, there's things that, people specialize in more than I do, whether it be products liability or elder abuse. But as you're concerned, how would you give advice in terms of picking a criminal defense attorney? Do you just pick one, or are there different things to consider based on the charge, the location, things like that?
Sure. I mean, of course, just like you're hiring a doctor or a dentist or an insurance agent, you would want to vet that person out. Of course, hopefully they would have a website. I do have a website. You would want to probably, if not meet them in person, at least have a lengthy conversation over the phone and just see what the rapport is between you and that person. You want to pick someone that specializes in criminal defense, just like you had said. There are different areas of law. There's multiple different attorneys out there that specialize in different areas of the law. So you would want somebody that specializes in criminal defense because that's what they do day in and day out. And of course, read the reviews, talk to other people that might know that attorney, and get a good feel for him or her.
We're just about out of time, but time enough for both of you to have a final thought. If you would, give us just a final charge from you to our viewers tonight.
Sure. I appreciate the opportunity to be on. Thank you very much. For any of those people out there listening, if you're in a criminal situation, you think you may be arrested or investigated, please feel free to reach out to my firm. It's Attorney Joshua Paul Jones. Phone number 205-970-6009. I give free consultations either over the phone or in person. But feel free to call me anytime. I'm usually very easy to get in touch with and love to help you out.
Michael, how about
you?
you?
I think my big takeaway here is that when you are in a situation, you've been arrested, that you have rights. And it's important on the front end to cooperate with the police. But if you are being arrested, they may not have your best interest at hand, whether you're innocent, partially guilty, or guilty. And you can use those rights to protect yourself. And one of those things is, in those moments, stay quiet, don't try to explain it away, and get an attorney involved because they will have your best interests in mind.
Interesting conversation. Thanks for being with us. Good to see you.
Thank you, gentlemen.
Thanks so much for being with us. Michael, thank you for leading the way tonight. Interesting conversation. Hope you enjoyed it and found it helpful. And again, as we say every week, and we really do mean it, we appreciate you being with us. And we know that you bringing us into your homes, that's a privilege of ours, and we are grateful for that. And hopefully you found the time tonight beneficial. We appreciate it once again. Thanks so much for being with us, and we'll see you next week, same time. We'll be right here. Have a great week, everybody.
Thanks for watching The Attorneys, sponsored by Hollis Wright.